In the trial of Derek Chauvin for the death of George Floyd, murder is the most likely outcome. I'm Andrew Esquire, and this is the Legal Mindset, where we give you the unfair legal advantage. And today we're going to talk about the Derek Chauvin trial that is going on right now and exactly what you need to know about the charges in the case and why they're so critical in understanding what the likely outcome of Derek Chauvin's case will be. Now let me just acknowledge one thing up front. This case is heavy. There are a ton of issues with this case that are hotly debated and that really push people on the left and on the right. So let's just get that elephant out of the way, that this is a huge and heavy case and is going to have huge outcomes no matter which way it comes out, guilty or innocent. But we're not looking at it from a political lens. That's not this channel. This is not the political mindset. No, this is the legal mindset. We're looking at things with a legal lens. And that's why I'm here. I'm here to give you that legal perspective on what's going on. And in this case, the legal perspective on Derek Chauvin's charges is vital. So let's start with what those charges are. We all know that George Floyd died, right? And we know that he's charged with murder, but that's not the entire case. So when you or I think about murder, a lot of times when you think about murder, you think about premeditated murder, and you think about something that requires intent to kill, intent to murder. That's what is triggered in your head. But in the law, there are different types of murder. Not all murder requires something called premeditation. Now, what's premeditation? Premeditation is thinking before you do something. So setting a plan, saying, hey, I'm gonna come over and I'm going to kill this guy at a certain date, a certain time, in a certain way. No, that's not actually required for murder. You don't have to think about killing that person. There are other types of murder that are unintentional, that do not require premeditation. So they can be unintentional murders and still convicted of a crime called murder. And that's exactly what we're dealing with in Derek Chauvin's case. So let's talk about the three charges. The first is second-degree unintentional murder. Second-degree unintentional murder. Now there is a second-degree intentional murder charge, but that's not what we're dealing with here. The second charge is third-degree depraved mind murder. That's also an unintentional type of murder. And the third is manslaughter. Now, manslaughter is often thought of as a lesser crime than murder, but it is still of the same type. It is involved in the death of a person. So that's really what we're dealing with here in those three charges. Now, one thing that popped out to me right away, just immediately thinking about this case, is that the prosecutors were actually pretty smart. And why do I say they were smart? Because they weren't like prosecutors in cases like Casey Anthony, the Casey Anthony case, or the case of O.J. Simpson, the famous O.J. Simpson case. In both of those cases, both O.J. and Casey Anthony, they both were charged with first-degree premeditated murder. And that's a huge bar. It is really hard to prove premeditation, to prove that you intended to kill someone. And that's honestly why those two cases failed. There are other factors, but the premeditation, the thought, the planning, that's one of the big reasons why those cases failed. And the prosecutors in both of those cases were criticized. People said, hey, look, you guys did a bad job because you went for the highest level of murder when you could have gone for an unintentional murder, which is what we have here in the Derek Chauvin case. And we don't just have one charge of murder. No. We have three different charges. So they have three different attempts to stick the landing, to get a conviction to stick. Let's start with second-degree murder because that's the most serious of the charges. That could carry up to 40 years in jail. Now, the sentencing guidelines dictate that a person with no criminal history, like Mr. Chauvin, would typically be assigned, under those guidelines of the state, 12.5 years in jail. But regardless, it is the most serious charge that he's issued with. So what is second-degree unintentional murder? Well, in the state where he's tried, what that means is a murder that occurs unintentionally while committing another crime. Now let's unpack that a little bit, because a murder that occurs while you're committing another crime requires you to prove another crime. And in this case, the crime they would have to prove is assault. They would have to prove that Mr. Chauvin assaulted George Floyd. Now, what does assault require? Assault requires intent. It requires premeditation. So in that way, for the second-degree murder charge, they're gonna have to prove an element of premeditation, just not involving the murder, but actually involving the assault. But that's a problem, because honestly, you have to prove that it was a criminal act he knew he was performing. And he's got a great defense, because as a law enforcement officer, well, he thinks he's doing his job. He doesn't know he's committing a crime. And it's really hard to prove that somebody knew they were committing a crime, that they had that intent to commit a crime. Sometimes you might hear the word mens rea. What that means is state of mind. And that's very important in criminal law. And I think that's the element that is lacking with the second-degree unintentional murder charge, because they're not going to have to prove it as much for the murder charge, but more for the actual assault charge. That's actually going to be really hard to stick. Now, stepping down from that, you have the very interesting case of third-degree depraved mind murder. Now, let's get a little background for this, because this one is really interesting. So this charge was actually challenged by Derek Chauvin's lawyer. They said, hey, third-degree murder in the state where he's tried is usually only for people who are injured unintentionally. So, for example, if someone fires into a crowd just indiscriminately and it hits a random person. So just an act which is not intended to hit one particular person, but just accidentally hits another and kills them. Well, initially, the trial court said, yeah, that's right. Third-degree murder, totally inappropriate to charge in this case. But the prosecution appealed, and the appellate court, which is a step up from the trial court, the ones who come back and review it, they call the play, they said, no. Third-degree murder, totally cool in this case. You can use third-degree murder in this case. And when did they decide that? Well, they decided that about a week before the trial started. In fact, the judge in the actual case, the trial judge for Derek Chauvin's case, allowed that charge to be added back in on Friday, right before jury selection started. So just to put a pin in this, that is a huge defense for Derek Chauvin, because his counsel wasn't given time to prepare. They were hit with this extra charge, which they now have to defend against right before the trial. There's a huge due process argument. That means he didn't get due process of law. He didn't have time to prepare, time to defend, time to think about that. That's a huge defensive strategy that Derek Chauvin's lawyer could use if they lose this case, if they're found guilty on any of the charges, particularly that charge. Now, another issue with depraved mind third-degree murder is the definition of the actual crime. What it requires is taking an action so extremely risky as to have a depraved mind, something inherently dangerous. Now, the examples of this are things like Russian roulette, shooting into a crowd, or a drive-by shooting. So imagine there's a drive-by shooting. There's a person in a car driving down the street or just randomly shooting into houses. By shooting into the house, you can expect, in fact, you're kind of hoping that somebody is hit. That's why you're doing the drive-by, to shoot in the house, not just to scare somebody. But that's not what we have here. Like Russian roulette, you'd have a loaded gun. You know there's a bullet in there. You know it's going to hit somebody playing that game of Russian roulette. Eventually, that trigger's going to pull. But why is that going to be hard to prove here? It's going to be hard to prove because there's tons of videos, photographs, documents, police reports of officers around the world placing a knee on a suspect's neck. That by itself, despite being a bad action, despite being not really justifiable, despite being brutal, you might even say, is not that level of danger. Just because you put a knee on someone's neck does not mean they automatically die. It's not the same as Russian roulette, shooting into a crowd. It's not something where you see somebody take the action and then somebody is really going to die. That's not something that you've seen in the documentation, so it's going to be hard to prove legally. And we'll get back to that legal point a little bit later. But let's stop at our last charge, which is manslaughter, second-degree manslaughter. And now, what does that require? Well, that's the lowest threshold. It's easier to prove than second-degree unintentional murder or third-degree murder. It's much, much easier. And honestly, it's pretty smart of the prosecution to include that, because all it requires is an unreasonable risk, a negligent risk. You're going beyond the standard. You're going beyond what's reasonable, what would normally happen. And that's much easier to prove. I mean, they could prove it if they could show that it was something totally not acceptable, never done before, and totally novel. The problem here is, but even with the manslaughter charge, is that it's probably been done before. It's probably even been done before in Milwaukee. The defense, while they haven't had a chance to present evidence yet, can probably find examples of times when officers, even within Milwaukee, have placed their knees on suspects. They can probably even find examples of other officers who have exceeded the use of force. And let's point out one thing real quick. The government is covering their butts. They are really protecting themselves in this case, because even so far, when we've just seen the prosecution so far, we've seen police officers and police experts come out and say, this is far beyond the use of force. This is a ridiculously harsh use of force. But those use of force policies, the policies that the police themselves wrote, well, they're really vague, and they're intentionally vague because they want to protect against excessive force suits. Those actual policies are really, really broad. They're not as narrow as the prosecution makes them out to be. And because of that, because they're actually really broad, and because a lot of crazy things happen, things which we probably should have a problem with, but they happen on a regular basis because these use of force policies are so broad. And because they're that broad, it's going to be difficult to even prove an unreasonable risk. Okay, now I know what you're saying. Andrew, did you clickbait me by bringing me in here and saying murder is the most likely outcome? No, because guess what? Reality sometimes conflicts with public opinion. And this is a huge case for public opinion. Here's the thing. Almost everyone has seen that video. Almost everyone feels a certain way about that video. And you can be sure that the people of Milwaukee, including the jury, probably feel a certain way about the potential outcome, the potential issues in the city if there was a not guilty verdict. So you could say that it's very likely there might be a guilty verdict just to calm everything down, just to keep everything steady. So if a guilty verdict is likely, there's likely going to be convicted of some charge. What is it going to be? Well, that's where that third issue, that third-degree murder comes into play, and that's why murder is the most likely. It's because there's now three options. So let's imagine you're in that jury room. You're sitting there with all the other jurors, and you're hotly debating things. Some people want to throw the book at him. They want to give him second-degree murder. But others say, look, it's really manslaughter. I'll give you manslaughter. I'll agree it's an unreasonable risk. I'll give you the lowest charge. Well, what happens? You can have a hung jury. You can walk out of there, or you can go with the third option. You can go with third-degree murder, the one right in the middle. Not as extreme as second-degree murder. Third-degree murder carries 25 years max, although the sentencing guidelines give it the same amount for someone with no criminal history at 12.5, but it's a middle charge and it still has murder on it. So the headline will be, Derek Chauvin convicted of murder. It'll just be third-degree murder instead of second-degree murder. And that's why I say that is the most likely outcome. And here, guys, is the reason why you need to understand the difference between real court and the court of public opinion.